Welcome to today's episode, I suppose, of our series of lectures on issues related to our Master of Arts in Financial Integrity program at Case Western Reserve University School of Law. The Master of Arts in Financial Integrity program is a master's degree housed at Case Western Reserve Law School, which provides students with a unique, comprehensive, and practical education in all aspects of preventing illicit international financial flows. I'm the executive director of the Master of Arts in Financial Integrity program. My name is Kathy Lesser-Mansfield, and I wish to welcome you. Someone has posted in the question that they can't hear anything. Is if someone else who is an attendee could post whether they can hear us or not, that would be terrific. All right, hearing no other problems, I assume whoever posted it's probably yours. People are saying they can hear and see. Great, thank you so much to those of you who responded. Next, I'm going to introduce Bill Cloninger, whose organization is also co-sponsoring this lecture. Bill, thank you.
Hi, Kathy, and all of the attendees. I'm Bill Cloninger, and I'm on the board of the Northern Ohio ACAMS chapter, and I'm just very pleased that we've been able to partner with the Case Western's Financial Integrity Institute and the Master's of Degree program in Financial Integrity. We've done now 4 or 5 of these lectures, and I'm just blown away by the number of people that have signed up to attend these. We've been averaging over 200 up to tonight. It's around 250 and so forth. It's really exciting to see that many people taking part. For the chapter, a couple of announcements. If you would like to participate in our board of directors, we are having elections in September, and please contact John Moody or Jim Hicksonbaugh if you are interested in running for a board seat. Also, upcoming future lectures in this series, we have a lecture scheduled for Thursday evening, July 8th, which Dan Stepano will present an update on the Anti-Money Laundering Act of 2020. He presented to us back in February when it was brand new, and there have been some developments in implementing the regulations and that sort of thing that will put some meat on the bones, and I'm really looking forward to Dan's presentation. And then on Thursday night, August 26th, we have another session, and we're working on putting that program together. So we've got a lot coming up, and thank you for joining us and taking time out on your Thursday evening to hear this very worthwhile presentation. So Kathy, back to you.
Thank you, Bill. So I get the pleasure of introducing our speakers who I attended a lecture by them at another university. I was so impressed with the work that they do that I knew we had to bring them to Case Western Reserve, and particularly to something affiliated with the MAFI program. The students who are taking the MAFI degree program will be studying the countering of the financing of terrorism this weekend. That's the subject of their course this weekend. And so we thought this was the perfect time to learn about domestic terrorism and the funding of domestic terrorism. So you all know, of course, that in August 2017, neo-Nazis and white supremacists descended on Charlottesville, Virginia, leading to a weekend of violence and the death of Heather Heyer. As a graduate of University of Virginia Law School, I was particularly horrified. I would have been horrified anyway, but it really struck home to watch the streets where I had walked when I was a law student being subjected to this kind of unthinkable and unspeakable violence. Our speakers tonight are from Integrity First for America, who in partnership with a legal team, including our speakers, have taken on the individuals and hate groups who were at the center of the Charlottesville riot and who are also at the center of some of the extremist and hate-filled movements that have led to later things like the attacks on the Capitol of January 6th. Our speakers today are Amy Spitalnik, and I'll introduce Amy first. Amy's the Executive Director of Integrity First for America. She is, which is a nonpartisan civil rights nonprofit that's backing the lawsuit against the parties who organized the Charlottesville riots. Amy has extensive experience in government, politics, and advocacy, including as communications director and senior policy advisor to the New York Attorney General, communications advisor and spokesperson for the New York City Mayor, and communications director in the New York State Senate. And she's also worked on a number of federal, state, and local campaigns and advocacy organizations. Michael Block, who is counsel from Kaplan, Hecker, and Fink, LLP, is an experienced trial attorney who spent over 7 years as a public defender at the Bronx Defenders and 3 years as a litigation associate at Williams & Connolly before joining Kaplan and Hecker. He's conducted numerous trainings on trial advocacy and criminal defense and was a member of the 2019 faculty for Harvard Law School's Trial Advocacy Workshop. He served as a law clerk to the Honorable Chief Judge Helen Ginger Berrigan and U.S. District Court for the Eastern District of Louisiana, and subsequently to the Honorable Diane Wood in the U.S. Court of Appeals for the Seventh Circuit. We just want to say that Michael's has some deadlines in the lawsuit tomorrow, and so he's been working sort of around the clock, and so we really appreciate you carving out this hour to share with us. So with that, I will turn it over to Amy and Michael, and welcome to Case Western Reserve.
Thanks so much, Kathy.
So we're gonna start by sharing a short video to bring us back to Charlottesville nearly 4 years ago at this point. And I do want to warn folks that, of course, given the nature of what we're talking about, there are some disturbing sounds and images in this video. And then following that video, we'll have a moderated conversation. And of course, please feel free to share your questions in the Q&A as we are chatting so that we can get to as many of them as possible.
Terror in Charlottesville.
Stark displays of racism.
Trying to promote
A car has rammed into a crowd.
victims thrown in the air.
Deadly act of domestic terror.
One woman dead, others critically wounded.
10 of the people who were injured in Charlottesville, including 3 of the people who were hit by that car and survived, have now brought a lawsuit against not only the murderer who drove his vehicle into the crowd, but also the leaders of all of the white nationalist groups that organized and promoted the Charlottesville event.
We are Integrity First for America. We are here to disrupt the extremism, to interrupt the cycle, to dismantle and bankrupt these hate groups and their leaders, to put them out of business, and most importantly, to stop the violence. Integrity First for America is leading the fight against white supremacy. Our Charlottesville lawsuit is the only current legal effort taking on the broad leadership of this movement, holding white supremacists accountable for their premeditated violence. We know that it's working. They're already facing huge financial and legal consequences. But we also know what we're up against. Bankrupting Nazis isn't cheap. These groups are still recruiting, weaponizing fear, and preparing for their next attack. Now more than ever, we are reminded of our obligation to dismantle the systems of white supremacy that poison this country. Turn your outrage into action, because hate has no place here.
Thank you so much for sharing that with us. So I just have one thing to say that I forgot to say, which is that you can post questions for the panelists in the Q&A, and we'll probably save most of the questions for the end. And of course, at the end, I'll be posting a slide and giving you the event number for this, for continuing legal education. So let me start with Amy. Let me start with you. Can you sort of take us back to 2017 and just fill us in on what actually happened in Charlottesville? I'm sure most people know in broad strokes what happened, but maybe give us kind of the details of what happened.
Absolutely. And I think that's right. I think we all sort of remember the broad strokes of that horrific weekend, but the details, given the craziness of the last 4 years, and particularly the ways in which Charlottesville really ended up being a harbinger or a preview of the cycle of violence that followed. The details might be fuzzy for some, and I think it's worth remembering that just 4 years ago, white supremacists were so emboldened, so empowered that they can attack an American city and violently attack people based on their race, their religion, and their willingness to defend the rights of others. First, on Friday, August 11th, 2017, you saw some of those images in the video. And I know we all remember viscerally what it felt like to watch neo-Nazis carrying tiki torches marching on the University of Virginia. They specifically chose torches to evoke the Nazis and the KKK. They chanted things like "Jews will not replace us," "Blood and soil," "White lives matter," descended on the university, where they surrounded a small group of peaceful counter-protesters at the Thomas Jefferson statue, kicked, punched, beat them up, threw fuel and lit torches at them. One of our plaintiffs who was there that night, an African-American undergrad at the university, said he thought he was going to die, and nearby an interfaith gathering had to shelter in place because it was so unsafe outside those doors. Ironic, because it was meant to be a safe space for the community to come together, and it ended up becoming a target too of these extremists. The next day, Saturday, August 12th, I think we all know sadly how the day culminated in the car attack that killed Heather Heyer and injured so many, including many of our plaintiffs. But it's important to really understand it was a day and a weekend of violence. It was a Saturday, and the local synagogue in Charlottesville was observing Shabbat. And these neo-Nazis this time marched on downtown Charlottesville under the guise of protesting the removal of a Confederate statue. But as we'll talk about, that was, of course, never the real goal of that weekend. They surrounded the synagogue, which is just right downtown, chanting things like Sieg Heil, carrying semi-automatic weapons, talking in their online chats about, quote, torching those Jewish monsters. And the synagogue had to evacuate congregants and Torah scrolls out the back. And the detail that always sticks with me, no matter how often I share it or read it in our complaint, is the fact that the synagogue was home to a Torah scroll saved from Nazi Germany decades ago. And in America in 2017, it was once again under Nazi threat. And that just puts such a fine point on what we're talking about here. The violence continued throughout the day. Of course, these Nazis charged a line of interfaith clergy, including one of our plaintiffs, Reverend Seth Wispelway. They specifically targeted and terrorized the Black neighborhoods in Charlottesville, both during that weekend and in the days after the violence, driving these white vans through those neighborhoods. And of course, the day on Saturday culminated in the car attack that many of us all know so well, in which James Fields drove his car into a crowd of peaceful counter-protesters, killing Heather Heyer, injuring many of our plaintiffs, as you saw in that video earlier. And what's so important to understand, and I think the crux of what we'll be talking about, is that nothing that happened in Charlottesville was an accident. It was planned meticulously for months in advance on social media and on other forums, down to discussions of whether they could hit protesters with cars and then claim self-defense. So that's not an accident. That's not a clash between different sides. That's a racist, violent conspiracy. And we have laws that are meant to protect against that. So it's those laws that our plaintiffs are using to hold accountable the 24 individuals and hate groups most directly responsible for orchestrating that violence in Charlottesville nearly 4 years ago. And at Integrity First for America, we are supporting the plaintiffs in this crucial litigation.
Great, thank you so much. And Michael, that's a perfect segue over to you to talk about the lawsuit. How did it come about? How did you get involved? What are the claims that are being made in the lawsuit?
Thanks, Kathy. So the lawsuit came about when Robbie Kaplan, who is the leader of this suit, was watching, along with members of the law firm, actually President Trump, talk about what had happened the weekend earlier in Charlottesville. And just the whole, I think it bears noting that Robbie started this firm in part to focus on public interest issues and to use the law to really fight back against important forces in society like white supremacists and wherever you could use the law to sort of serve the public interest. And you know, that weekend and the aftermath was so upsetting to Robbie and to the folks at the firm that within 48 hours, Robbie was on a plane to Charlottesville, talking to community members, talking to the people who were most impacted by it, and filed this suit within a couple months after that. The basis for the suit is a federal statute called the Ku Klux Klan Act of 1871, which is a statute that was passed by the Reconstructionist Congress that was intended to combat vigilante justice meted out on the basis of race and religion, such as what we have here. And so the Ku Klux Klan Act prohibits conspiracies to commit racially motivated violence, which turns out exactly what happened in Charlottesville. Shortly after Charlottesville happened, there were some of the online chats where most of the rally was planned on a website called Discord, was leaked, and you'll see if you read our complaint, it sort of lays out this fantastic and very, very specific array of plans by the defendants in our lawsuit to do exactly what they did in Charlottesville, which is conspire to commit violence against Jews and Black people and their supporters.
It helps if you unmute, doesn't it? Who are your plaintiffs in the lawsuit, and who are you suing?
So the plaintiffs are folks from Virginia that were injured in various aspects of the rally that weekend. So as Amy laid out, there was violence that occurred Friday night on UVA's campus, and then additional violence that occurred Saturday in downtown Charlottesville. Our plaintiffs are people that were injured in either one of those days or both, including I believe 7 people who were actually hit by James Field's car. And they are individuals who came out that weekend to stand up, to basically be present and to speak out against hate and white supremacy. It was very, very well known around town that Unite the Right was going to be happening that weekend, that there were going to be white supremacists from all over the country coming to Charlottesville. And our plaintiffs came to be present and to stand up for their community and peacefully protest. And each were injured in some sort of aspect of the conspiracy. On the other side, the defendants are essentially the leaders of the white supremacist movement in this country, which makes sense because what they wanted was to plan the biggest white supremacist rally in history. And so although white supremacists often actually are characterized by a fair amount of infighting, they got together, they actually titled their rally Unite the Right, because they all sort of came together to plan this event. And so our defendants are leaders in that movement. So some of whom are household names like Richard Spencer, Jason Kessler, Chris Cantwell. And then some are less well known, but no less dangerous, and they're very prominent leaders in the white supremacist community. They have a number of followers, they lead a number of groups, and they are the folks that played the most active role in organizing the event.
And to build on what Mike is saying, I think it's worth specifically noting how central a number of these defendants are to the broader white supremacist movement, the ways in which they weren't simply the ringleaders of what happened in Charlottesville, but also, unsurprisingly, have really deep and disturbing connections to the broader movement and the broader cycle of violence that has followed Unite the Right over the last 4 years. We know that, for example, the Pittsburgh shooter communicated with some of the Charlottesville leaders before killing 11 Jews praying in synagogue 2.5 years ago. The Christchurch shooter, who killed dozens of Muslims praying in 2 mosques in New Zealand 2 years ago, donated to 2 of our defendants, Richard Spencer and Andrew Anglin, and then painted onto his gun a white power symbol that was popularized by a third, Matthew Heimbach, in the gun he used to murder dozens and dozens of Muslims praying in mosque. And the Poway, the Christchurch attack was live streamed on Facebook and in turn inspired the Poway Chabad attack 2 years ago, the El Paso Walmart attack, which happened 2 years ago this summer, and so much more. Of course, the parallels with the Capitol insurrection are quite stunning as well, both in terms of the playbook and some of the ideology. And so it's really important to understand how central these defendants are, the ways in which taking them on and holding them accountable for what happened in Charlottesville, of course, have much larger impacts because of their centrality to this movement. And also the ways in which this cycle of violence works, in which each attack is really used to inspire the next one. Because largely the lack of accountability we've seen in recent years and the ways in which these various tools and tactics work, including social media, to perpetuate the cycle.
You know, when I first heard you guys speak, I couldn't help think about the Southern Poverty Law Center suit against the KKK that pretty much bankrupted the KKK. And so that brings me to the question of, do these guys have any money? You know, do they have any assets?
Yeah. Go for it.
Sure. Well, I guess the short answer is we'll find out, perhaps. You know, I think we certainly didn't bring the lawsuit with that as a paramount focus. I do think it's important that our clients who were grievously injured on August 11th and 12th are compensated as much as possible. But I think, you know, the primary focus of the suit is to, among other things, provide a disincentive to doing this, you know, to planning a hateful, violent rally in an American city. And, you know, as a civil litigator, the tool we've got to do that is financial. So our hope is that the lawsuit, to be frank, bankrupts these defendants in terms of whether or not they have assets that will. I think the short answer is it's not clear, but I don't think there's a. You know, I think the incentive is really what we're focused on, and that's what hoping what we'll get from a judgment.
And I will say that particularly over the last few weeks, we've seen these defendants aggressively raising money, supposedly for this case, with a very large online fundraising effort that has been promoted by a number of white supremacist podcasts and other leaders. And that, of course, you know, brings out sort of a deep well of support from white supremacists online. To give you an example, one of the accounts on, I believe it was Telegram or Gab, promoting this fundraiser goes by 14HH. That refers to the 14 words, which is a white supremacist slogan, and HH refers to Heil Hitler. And so to give you a sense of how, of course, what motivates these people and their supporters, but of course, who's now rallying to financially support this effort, or rather to financially support the defendants, supposedly for their legal fees. And so we're seeing this unfold. And of course, we have our own expenses in the case that we are fundraising for. There's certainly a stunning juxtaposition between who is supporting the plaintiffs versus the defendants in this case. And it gives you a sense of sort of, you know, their ability to fundraise, how they rely on the white supremacist network to support them. And it's that same network that, of course, they relied on and recruited to come to Charlottesville in 2017.
Great, thank you. So Michael, what year was the KKK Act? You said it earlier.
1871.
Okay, so we all want to know what made you dig up an act from 1871 and think you could employ it in this way, and how does it relate to the claims that you're making? And are there any other claims not based on that?
Yeah, that's a great question. So, I mean, the short answer to how it came about is the brilliance of Robbie Kaplan. I think the suit was modeled on a number of different suits, including a suit that Robbie was a part of, where basically people that were killing the doctors that performed abortions were targeted in a lawsuit that was very effective in providing a disincentive in that suit. I think it turns out this act is an incredibly well-tailored statute for exactly what happened here, not just because both in its purpose was essentially created to deal with the Klan and the vigilante justice that they were beating out in the 1870s. But the elements itself are really sort of exactly what the facts bear out in this case. It's conspiracy to commit racially motivated violence. So, but essentially sort of how it started, it's really the brainchild of Robbie Kaplan, who just sort of dusted off this old but very, very important statute to go after exactly what it was enacted for. In answer to your second question, there are additional claims in the case. There are state law, Virginia. So the Ku Klux Klan Act is a federal statute. There are also some state law Virginia statutes that we have alleged against these defendants that are similar in nature. It's a civil conspiracy statute, some sort of typical tort statutes in terms of assault and battery and things like that. But the sort of primary statute is the KKK Act.
Great, thank you for answering that. And we should say, obviously, Michael has a child who's in the background, and we're all used to this on Zoom now, right? Usually my cat's wandering in front of my face. Has the case already, even though you're not at trial, well, where are you in the case? Let me start with that question.
Yeah. So we're at, I think, a very exciting part of this case. So we have largely completed discovery. So we have gathered just about all of the documents and data that we're entitled to. We have taken the depositions of each of the defendants in this case, which, as you might imagine, was dramatic and also fruitful. We have survived a motion to dismiss, a motion for summary judgment. We survived a motion to preclude our experts. We have won a number of discovery sanctions rulings that will be very helpful at trial. And we are now 4.5 months away from trial, which starts in October. And so we're really kind of at the beginning stages of putting the trial together and getting ready.
And do you think it's had any impact on the people that you're suing? I mean, it's hard from a public view to see any impact because, we've continued to have these violent right-wing attacks, particularly the attack on the Capitol on January 6th. But are there impacts that we're not seeing?
Yeah, absolutely. It's been, I think, really stunning in some ways, the financial, the operational, the legal impacts the case has already had on some of the defendants. Some, like Richard Spencer, have said publicly that this has been financially crippling, and combined with his deplatforming from social media sites has made it very hard for him to operate. which I think speaks to not just the power of accountability, but also the power of removing these extremists from social media, because it limits their ability to fundraise and to spread their violence and their hate. Other defendants, as Mike alluded to, have faced large sanctions and other penalties already, 5-figure financial sanctions. 2 have had bench warrants issued for their arrest, and 1 has already sat in jail for contempt of court. And our Mike and our team have won, at this point, 3 adverse inference rulings against 3 different defendants, which will, of course, have an important impact at trial. Many of the defendants have lamented how, they can't go about their business. The League of the South, which is a neo-Confederate hate group, and the defendants said they can't open a new building because of this suit. Some have claimed that they are leaving the movement, and while there's a lot of skepticism around that, it speaks to the power of accountability. A few have tried to rebrand. And I think you're right. Obviously, the case alone is not a silver bullet that is going to solve the crisis of extremism, but it can do a few things. 1, it can make crystal clear the consequences for being a part of this sort of racist, violent conspiracy, both in terms of the impacts already and more broadly, when we win large financial judgments at trial, that deterrent effect it can have, not just on the defendants and on their supporters. And we are already seeing, for example, some of the defendants saying they didn't want to participate in subsequent Unite the Right Charlottesville related actions, like Charlottesville 3.0, as they dubbed it, because they didn't want to be sued again. So that's important. But I think more broadly also, there are impacts that are so important to understand. There's the financial impact on this movement, bankrupting, disrupting, and dismantling the leaders and the groups that are at the center of this movement. There's also the ways in which this case can really serve as a model for accountability at a time when we need it. And so if we, as a small nonprofit with our incredible legal team, but a relatively small operation, can effectively financially cripple Richard Spencer and other leaders of this movement through civil litigation like this, imagine what would happen if DOJ were operating at full capacity, if other NGOs and nonprofits were helping to hold these extremists accountable, if there were the resources to do all of this in the way that, particularly over the last 4 years, has been sorely lacking in a number of ways, particularly as it relates to DOJ. And so if we can do this, imagine what would happen if the full weight of our government and the private sector and NGO space were brought to bear using the tools we have to hold these extremists accountable. And of course, there's the model that this provides. We're already seeing other cases under the Ku Klux Klan Act, 2 cases brought following the Capitol insurrection using the same statute, a different section, but the same overall law. And the ways in which this case can really be a model for accountability is crucial. And more broadly, of course, and Robbie Kaplan frequently says this, is that every few years there's a trial in this country that is about more than the parties and more than the minutia of the trial, but really about a public reckoning on an issue that is desperately needed. And if you look at the Prop 8 case in California nearly a decade ago on marriage equality, just before Robbie went to the Supreme Court representing Edie Windsor, the ways in which that helped shift the public consciousness, go back to Scopes Monkey, so many in between. Cases like this can play a really important role in driving a public conversation and changing the public's understanding of a crucial issue. And so when we go to trial and lay bare the violence, the hate that's at the core of what happened in Charlottesville, at the core of how these extremists operate, that will be powerful, not just for Charlottesville, not just for Virginia, but hopefully for this whole country that desperately needs to understand this crisis.
Great, thank you. You mentioned the tools that we have, and I guess I have a question about a tool we don't have, which is we have a fairly robust system for denying funding to international terrorist organizations, and we are lacking in that area for domestic terrorist organizations. Is your organization interested in or participating in any sort of legislative advocacy to change that or to increase the ability of the US system to sort of deny funding to domestic terrorists in addition to international terrorists?
I can start, and Mike, if you want to jump in here too. I know you've been thinking about some of these issues more broadly. I think I'll say a few things. I think first and foremost, it's important to note that there's a lot that can be done with the tools we have. And I don't want anyone to sort of look at this situation and use it as an excuse to say, we can't be holding extremists accountable right now. There is so much that if we use the tools we had to hold extremists accountable over the last 4 years, imagine where we would be. And that includes both the federal government and state and local governments, includes NGOs like us and private plaintiffs like our plaintiffs. And so there's a lot that we can do within the tools we have, and it's important to recognize that and call that out and not use it as an excuse for inaction, which is oftentimes the case, a variety of different fronts. I think that there is a very important debate happening right now, not just about the question of how we actually deal with the question of funding for domestic terror, which is important. And I think, for example, I believe former Congressman Max Rose had a bill in the last Congress that would help apply some of the same standards for funding foreign terror to how we hold accountable those funding domestic terror. And it was a really, I think, important bill that helped drive a conversation on this at the very least. There's also a broader conversation happening around whether we need a domestic terror statute and a variety of other new tools in the toolbox. And I will say that I would caution that while there are certainly new tools that could be helpful here, it's important that if we do implement these new tools, we do so in a way that continues to protect the civil liberties and the civil rights of groups that might be targeted by abuse of those laws. And many civil rights groups have been clear about the importance of making sure that if there is a domestic terror statute, it does not infringe on people's civil rights. And whether or not we can effectively walk that line, I think is still a debate that's happening in Washington among a number of advocates and other experts in this space, and something that we are closely watching. And regardless, I think it's so important that we not rely on the outcome of that debate and continue to use the tools we have to hold these extremists accountable however we can.
Great. Mike, do you want to jump in on that too before I ask the next question?
Sure. Yeah. I mean, I just agree wholeheartedly with what Amy said. I think I was a public defender for 7 years in my last life. And so I just have an instinctive hesitancy about dealing with an issue by criminalizing more behavior. And I think a domestic terror statute does have for abuse. And I also agree that there's a lot more that can be done based on with the tools that we have. And I think in obvious ways, I think part of the problem in the last 4 years is a sort of lack of political will to focus on white supremacists, which deserves to be, the highest priority, but doesn't necessarily require, in my view, criminalizing more behavior that could be used to target, to use for abuse.
Okay, great. One of our attendees asked a question, which is kind of in line with what I was going to ask about next. The question is, are either of you concerned about personal backlash or your personal safety? And so can you maybe talk about that a little bit?
Yeah, this is the fun part of the conversation where I'm always grateful my mother isn't watching when this comes up, because maybe she is watching this one if she is. Hi, Mom. But I will say this is the least pleasant part of this work and of this case, in the sense that the defendants have tried every trick in the book to avoid accountability, as Mike mentioned earlier, and that includes using harassment and threats of violence to try to intimidate plaintiffs and our legal team and IFA from holding them accountable. So in some cases, that's direct threats against us, our legal team. Chris Cantwell, who's one of the defendants, specifically targeted Robbie Kaplan a few summers ago, talking about all the fun he was going to have with her in much more misogynistic and anti-Semitic terms. Some of the defendants have been particularly keen on targeting me lately, like Michael Hill of League of the South, who posted about how I should be scared of him. And other defendants like Jason Kessler seem particularly obsessed with us and talk about us quite frequently on their social media. What's in some ways even more concerning than the defendants' chatter is their ability to rile their loyal followers to action. And that means inspiring people on social media to take action, to turn these harassing comments and other threats into real world steps. And so, to be completely frank, the biggest line item in our budget at IFA is security. We are so grateful to have incredible amounts of legal work being done pro bono, donated by brilliant attorneys like Mike and the team. But at the same time, there are major expenses in this case related to security and evidence collection and other needs, with security outweighing all of them because of these threats and the need to both monitor the threats against us on a regular basis. And of course, when we go to trial this fall, ensuring that our team and our plaintiffs, our expert witnesses and others are safe while we're actually on trial and in any other sort of in-person setting. And so, you know, as I said, these defendants use the threat of harassment, use the threat of violence to try to intimidate people and away from holding them accountable. We're not going to let them do that, but we're certainly going to take precautions to keep our team safe.
We have a question in the chat that kind of takes us back to the incident itself, but I think it's an interesting question, which is why Charlottesville as opposed to any place else? Have you discovered anything about, you know, what made these people pick Charlottesville as the location for this?
Well, it's funny that that question comes this week because actually the Charlottesville City Council just voted, I believe on Monday, to finally remove the Confederate statues that were the pretext for the Unite the Right violence. As Mike and I both described, of course, the purpose of that weekend was always violence, as our lawsuit makes clear. But it's a particularly poignant question this week when nearly 4 years after the fact, there is the actual vote to take those statues down. I don't know, Mike, if you want to build on that or add anything.
Yeah, well, so the as Amy said, the pretext was the vote to remove the statue. But the reason why Charlottesville in particular is, you know, these defendants, they think of themselves as building a movement. And it's a movement that depends on, among other things, attention. They know that if they go to a more progressive city, they are going to get, and they, you know, the more sort of bombastic and frankly racist and anti-Semitic and violent they are in a more progressive city, the more there's going to be a backlash, the more people are going to come out and counter protest, the more that they're going to get attention. And so Charlottesville was one of a number of cities that summer that that defendants, white supremacists generally, including some of our defendants, were targeting for different kinds of rallies and propaganda and attention, including Berkeley, California, a number of times. And Charlottesville a number of times earlier that summer before August. So the city council vote certainly gave them the pretext to, sort of make it seem like there was a legitimate issue for them at stake, but they believe that their movement depends on attention, and so they often refer to what they try to do is quote unquote trigger liberal towns, which is sort of generate this uproar in response to their presence.
So in a minute, we're going to turn to the questions that have been posted in the Q&A. But before we do, I just want to say, as now somewhat older attorney, it's really inspiring to me to see younger attorneys and younger policy advocates and social justice advocates taking on a fight like this. So I just want to say I am incredibly impressed with you all. And I guess I just want to know what people who are watching can do to help. What is there for the rest of us to do who aren't in the ditches litigating this case every day?
There's so much that people can do. And I think first and foremost, spending time coming to a program like this is enormously helpful. I know that there's a lot on people's plate, and this isn't the most uplifting of topics to necessarily talk about during your free time, but investing in making sure that we are actually telling these stories, making clear what happened in Charlottesville, and learning about it and engaging on it is so important, particularly at a moment when you have white supremacists and other extremists trying to rewrite history, both through around January 6th, but also even in our case where the defendants talk about how they hope to quite literally rewrite history and whitewash what happened. And they don't want it to become another Selma, as they say, when of course we should make sure that people actually understand how vile and how violent that weekend was and how it was intended to be. What people can do, there's so much. First, get involved with Integrity First for America. We're a nonpartisan 501c3. You can get involved by signing up for case updates on our website to make sure you know what's going on at trial this fall and keep updated there. If you have the ability to donate, please know that every dollar directly supports this case, and specifically those security and evidence collection costs that I mentioned, and that your gifts are also tax deductible, which is always helpful. And we are grateful for whatever folks can do, and spread the word, whether it be through posting on social media, there's sample content on our website, sharing this event after the fact with friends, colleagues, neighbors, whomever might be interested. Or if you're interested in working with us on a program like this for your own organizations and communities, you can reach out to us at contact@integrityfirstforamerica.org or on our website, which is also integrityfirstforamerica.org. So there's so much you can do there. More broadly, though, we're dealing with a crisis of extremism in this country. Every single statistic points to the fact that we're looking at record levels of hate crimes, of domestic extremism, of anti-Semitism, of conspiracies and disinformation. And we are not powerless in this moment. There are tools we can use, whether it be our justice system, whether it be our power as advocates, to our officials on all levels of government, to the private sector, and making sure the federal government the social media companies are not giving a platform to extremism, which by no means is something the First Amendment requires as private companies. And so making sure we're using the power we have as consumers, as constituents, whatever it is, as people who donate, whatever it is that we can do, please keep doing it. Make sure that when the news cycle moves on from the next awful attack or in the next coverage of this sort of extremism, our own advocacy is not moving on. Our own engagement on this is not moving on. We're continuing to ring the alarm bells of this crisis.
Great, thank you so much. I'm going to start asking some of the questions that people have posted in the chat. The first one probably isn't a very long answer, but the question was whether you considered using civil RICO against these defendants, which is the Racketeering and Corrupt Influences Act.
Yeah, so the short answer is we considered kind of every conceivable tool that might fit, and without overreaching. I think one of the problems with RICO is we're dealing with a case that's not really, it's certainly, I mean, it's not one enterprise. It is really, there were probably 7 to 10 groups that all got together for this one event. And so what you have there is pretty clearly a conspiracy, which is just a legal agreement to do something illegal, but not necessarily an enterprise that we could go after, which is really at the heart of RICO. So it's a great question. It just doesn't seem to be as tightly fitting a statute as the one we brought this case under, and we really didn't want to overreach.
And in a related question, one of our teachers, who is a former prosecutor at the Justice Department, asked if the Justice Department has shown any interest in using prosecution options. Sorry, words are not coming out.
So, I would say yes and no. Yes, in the sense that there were prosecutions by federal prosecutors that came out of Unite the Right. It was, in our view, kind of the low-hanging fruit. And by that, I mean, like, James Fields, the driver of the car, was prosecuted. There were a handful of individuals who were at the center of the violence that were prosecuted. But there wasn't really an effort to go after the leadership of any particular organization or the lead organizers of this particular event. And so that's kind of a gap that we hope that this lawsuit would fill, is that we could use the legal system to go after the leaders of the event and the folks that were really behind the planning and the organizing and the driving force of the real destruction that happened in Charlottesville, as opposed to a few individuals that committed individual acts of violence.
Do you think there might be a similar suit arising out of the Capitol, civil suit arising out of the Capitol attack? Excuse me, the tourists just touring the Capitol on January.
Right. You know, I think so. There are a couple suits that have come out under the KKK Act, albeit a slightly different provision from the one that we sued under. You know, it's hard. I mean, it's hard as a factual and legal matter. If you want to put together a case that really goes after organizers and people behind the scenes, as opposed to, you know, the people that were front and center committing the acts of violence, it's a more difficult, labor intensive task to do the digging that you need to do to find the planning that went on, and to actually put together evidence of those trickier laws to prove, like conspiracy or RICO. I mean, I think, you know, I think it's possible to put together such a suit based on what happened on January 6th. But, you know, as we've been learning in this case, I mean, we've been litigating this case for 3.5 years, and we spent 3 solid years in discovery fighting for information and gathering from white supremacists and trying to get their social media accounts. And it's a very, very difficult to put together a case like this is not trivial. And so I don't, you know, I will also say that one difference is that the Justice Department is far more active here in targeting many more individuals that played some sort of role in January 6th. And so, you know, there just may not be the need as much to sort of put together a massive suit like we have going after kind of all the major organizers.
Great. We actually, believe it or not, only have time for one more question. And so I'm going to ask the question and then we'll ask for your closing remarks. So one of the attendees asked, how do you see the future of laws being passed by states, making it lawful to drive an automobile into Black Lives Matter protests, injuring and even killing people? Shouldn't the laws be unlawful given the KKK Act?
Do you want to start, Mike?
Sure. Yeah, I mean, those laws are just disastrous. And, you know, not just because they actually immunize people from liability for really heinous acts, which is bad enough in and of itself, but also the messaging of it, the message being that, like, there's something about that those in political power support driving into counter-protesters as a way to deal with counter-protesters. You know, we can say confidently really emboldens people like white supremacists to do it. And I say that because of the chatter that we've seen leading up to Charlottesville, involved people that were involved in planning Charlottesville saying things like, hey, I heard it was illegal to run over counter-protesters. You know, that blunt statement isn't true today, and it was even less true back then, but it gave people a feeling that maybe it was. And so people, as we've seen in Charlottesville, act. And since Charlottesville, we've seen probably 100 car attacks. I forget what the number is up to now.
Yeah. And so I mean, literally just 2 days ago, 4 Muslim Canadians were killed in a car attack by an Islamophobic extremist up there. And as Mike said, literally dozens and dozens over the last few years, certainly totaling over 100 here in the United States.
Right. So yeah, I think they're
Sorry, go ahead.
dreadful.
Sorry.
No, that's it. Yeah.
Yeah, I just wanted to, I wish we had another hour to hear more about this, although Mike is on a deadline on a brief, and so he would probably not want to have another hour.
No, that's all right.
But we so appreciate you joining us. I just want to ask if you have any closing remarks, and then when you finish, I will go ahead and post the CLE number for our attendees and read it out loud. And also, if you are attending this for CAM's CE credit, ACAM CE credit, you need to fill out the same form that's linked in the slide I'm going to show, and then we forward that to Bill Cloninger, and he makes sure that you get CE credit. So any closing thoughts before we post the CLE numbers?
Okay, I mean, I think there's a lot of reason to feel helpless and hopeless and scared in a moment like this when we're watching all the statistics point to a crisis of extremism, and the Department of Homeland Security, even under President Trump, saying that white supremacy is the most persistent and lethal threat to this country. Every statistic, every fact seems to point to this being a crisis, and it's easy to feel like there's not a lot that can be done about it. And I think what gives me hope in a moment like this is that we actually do have tools. We can use our justice system. We can use our laws like the KKK Act to hold these extremists accountable in a way that is so crucial. And the fact that there has been so little accountability in recent years is a testament to the importance of accountability in cases like this, because when we do actually seek justice, when we do fight for accountability in moments like this, it has real impacts, as we're seeing in this case, and as we will certainly see come trial this fall. And so if you are, again, interested in getting involved and supporting this effort, please do reach out to us at integrityfirstforamerica.org. Let us know if you want to host a similar program, if you're able to donate, and do whatever you can to sort of keep beating the drum on the crisis of extremism and what we all can do to make sure it doesn't fall off the radar screen, even as the news cycle moves on.
And I would just add to that, what I find heartening is that that there are panels like this where so many people come out and participate and think about these issues. I do think, as Amy has mentioned, I do think violent white supremacy is one of the most kind of important, dangerous issues of our time. And I think I think in some sense we have, I don't know if turned a corner is the right word, but we're sort of back to a point where we have the political will to prioritize it. And I agree with what Amy said earlier, which is just sort of don't let this issue fall off the map. Keep coming out to these things and talking about it and tell your friends. And I think that in and of itself is really doing something important. So I just very much appreciate this panel and everybody coming out.
Yeah, and I just want to say I really encourage people who are attending this to sign up for at least updates from Integrity First for America, because as the trial gets closer, I don't think we can anticipate what your needs might be, and so I know that you keep people very closely updated with what's going on. So thank you so much to both of you. I'm going to now share my screen to show you all the CLE number, and I'll also read it out loud. Slideshow, hang on a second, from the start. So the CLA activity code is